Second one is the perceptual succession. This means that the company continues to exist even if the members or the directors changes. Third one is the limited liability. This means that company shares of the company is only the liable that amount which is invested in the company. Common seal, it's optional because it's optional because it is the official signature of the company. Transferability of shares. This means that the transfers of all shares to the company from one person to another and one person to another according to the legal trials. Next one is the company law, types of company law. There are three types of company law. First one is the one-person company, private company, and the public company. One-person company have a one directors, minimum of one members, and separate legal entity. It is suitable for the small businesses to run. The next one is the private company. Private company have the two directors and minimum of two members. And in this, the shares are not open to the public. It complies to requires the one-person company. Third one is the public company. It has the three directors. It has three directors and minimum 7 members in the company. And its shares are offered to the public. And it has the compliance with strict regulations and disclosures of the company. Next one is the incorporation of the company. First one is the obtained digital signature certificate. This means that the required it is a digitally signed company's registration documents online. Next one is the apply of directors identification number. This means that the DIN number is a unique identification number which issued to the companies of the director. Reserved company name. This is a unique company name which is offered by the Ministry of Corporate Affairs. Next one is the file incorporation document. This means that submitted all required forms and documents to the registrar of the company. Receives certificate of incorporation. This receives the certificate by the registrar of the company which officially establishing the company. Next one is the company directors of the company. So the director of the company. The director means a person appointed to manage and oversees the affairs of the company. Directors are responsible for making the important business decisions and enhancing their decisions, which ensures the compliances of the company with the legal requirements. There are 15 number of directors and more than 15 numbers of directors which appointed that passing the special resolution. Here are the duties of the directors. First one is the act in a good faith. Act in a good faith. Second one is ensures compliance with laws, protect company assets, avoid conflict to interest, and maintain the transparency. Act in a good faith. This means that the directors must act honestly. That the directors must act honestly. Ensures compliance with laws. This means that the company which compliances it have the legal. This means that the company have a legal rules and regulations. Protect company assets. This means that the company protects its assets. That the company protects its assets from the company. Next is the regional directors. Regional directors is a senior directors senior directors of the Ministry of Corporate Affairs, which represents the central government in matters. This directors oversees the company, company law and administration, and ensures the compliances with the Companies Act 2013 in the particular regions of the company. Regional director also plays the important role in the corporate regulations, handling approval, appeals, inspections, and other matters which delegate the central government of India. And it also functions to the registrar of the company and registrar of the company and ensures the compliances with the provisions of the Companies Act 2013. Here are the list of the headquarters in the regional directors. First is is New Delhi, Chandigarh, Ahmedabad, Mumbai, Navi Mumbai, Chennai, Bangalore, Kolkata, Guwahati, and Hyderabad. These are the regional directors headquarters which have its companies. Next one is meetings in a company. Meetings are the essential parts of the management which governs in a company. Uh, uh, which governs in a company. Meeting is a formal gathering and the shareholders, directors or members of the company to discuss and makes a decision on a company's matter. Next one is the types of meetings. There are the four types of meetings: the board meetings, annual general meetings, extraordinary general meetings, and class meetings. The board meetings. Board meetings are the meetings meetings of the directors to discuss and decide on the company's management and operations. The annual general meetings are the meetings which yearly meeting of the shareholders to review the company's performance and financial statement. It's held on every year or the yearly based meeting. Next one is the extraordinary general meeting. This meeting is a special meeting which helps to discuss the urgent and important matters next to the AGM, which is the annual general meeting. Class meeting. Class meeting is a meeting which means that the class of the shareholders to discuss the matters which affecting the their publics, which is a specific rights. Next is the conclusion. Overall conclusion of this company law. This is a basic company law discussion. So the overall conclusion of this is the company law governs the formation and the management of the companies under the Companies Act 2013. So it defines that the rules, directors and regulators. Meetings ensures the legal compliance that protects the stakeholders and promotes the transparency and the good corporate governance. So it is essential for the smooth functioning and the growth of the businesses. Thank you.
Anybody has any question? I think समझने हम लोगों ने इसको एक बहुत प्रैक्टिकल अप्रोच ली उन्नति ने लीगल बेसिस पे बताया तो किसी के पास कोई क्वेश्चन हो तो उन्नति से पूछना चाहता हूँ so before